Good afternoon, everyone. Good afternoon. We are live here on 107.1 FM. This is your program. We're here live to you on The Law and You. I'm your host, Shellon Washington, and I'm here today with my co-host, Claremont Chung. And today we'll be decoding sections of the ExxonMobile contract for the people of Guyana. This is the contract that is specific to Guyana. We're not speaking about any other contract this afternoon. This conversation is restricted to the ExxonMobile contract between the government of Guyana and ExxonMobile. It's a pleasure to be here with you this afternoon. Again, I am your host, Shellon Washington, and I have here with me today Claremont Chung, ESQ. He's also an attorney. Claremont, you could go ahead and introduce yourself to the audience. Say hi to the audience.
Well, I'm glad you gave me a promotion from guest to co-host, which I'm going to hold you to that, and I'm going to have some opinions of my own. But for those who don't know me, my name is Claremont Chung. I'm an attorney admitted to practice in New York and New Jersey, and anything I say here today is just a way to guide you to whatever decisions you make, whether they're ones that has to do with the law or whether it has to do with personal philosophy and how you feel about particularly the contract between really a subsidiary of Exxon, which is SO, operating in Guyana, and the contract between that company and the Guyana government operating in the name of the citizens.
Yeah, so today we'll be, like I said, we're going to be decoding specific sections of the contract between the government of Guyana and ExxonMobile. For those of you who are interested in what has been taking place in Guyana, in case you've been wondering what was going on, what is taking place between Guyana and ExxonMobile, we've been seeing so many things in the news. The last we saw was as it relates to the taxes that was due to Guyana. We saw that there was a compromise. Then we saw the government of Guyana came back and said, no, there was no compromise. They did not agree to forego a large portion of the money ExxonMobil owes to Guyana for a mere fraction of that money. The government of Guyana came out and said that's incorrect. So we are not sure what's going on. So we're going to be decoding sections of that contract so that the people of Guyana will be enlightened as to what is happening under your nose. There's things that you need to know about that contract, which no one tells you about. And just so you know, the contract is I don't think it's very comprehensive at all, because if you compare our contract to that of countries who have been engaged in petroleum exploration and exportation for many, many decades, and they're very familiar with this type of deal, the contract will be much, much more comprehensive. It will be ironclad. It will be very, very fair in terms of the negotiating, in terms of the agreement between ExxonMobil and those countries. Before we get into the questions this afternoon that we want to discuss with our audience, what's your real opinion as it regards that contract? You've read that contract. What is your general opinion? We're not going into the specifics as yet, but what is your general opinion on that contract?
Well, it's what we call in the law, if I had to use one word, it would be unconscionable. And though it's a big word, it really means contracts that is so one-sided that the persons or the party that benefiting on the stronger portion is really have taken advantage of the other person on the other side of the contract. That is, no reasonable person would enter into such a contract on either side, because both in this case, the stronger partner, which is Exxon, 300 billion company, and the weaker partner, Guyana, is a 3.5 billion company. So there is no, what we call the meeting of the minds. There can be no equity between parties that is more than 100 times. One party is 100 times stronger financially in terms of just capital than the other. And especially when that contract is designed to benefit the stronger party, and it's something that they are pursuing on there is their contract. This contract wasn't prepared by that's, for the lack of a better word, the weaker party. So unconscionable is the word. There are other things I could call it, but for the purposes of today, I think we should concentrate on termination and what happens in the event that it could be, if it could be terminated at all, is one question, and then what do you do? What does termination really mean? What are the steps? And you'll see who holds the real power, and why signing a contract like that for both sides was really unconscionable.
I absolutely agree with you on that one. Just as you know, as an attorney who is familiar with contract law and how that operates and what it means for the parties, as you heard Clement rightfully said, in order for a contract to even be valid, there must be a meeting of the mind. Both parties have to understand the nature of the agreement that they're entering to, and both parties must agree to all of the terms that they're entering into. And from what it appears, is an equal bargaining position of both parties. You have one party on a stronger bargaining position side, and then you have another party on a weaker bargaining position. And that comes about because Guyana has never entered into a contract of this nature. And my fear is they did not have anyone who was competent enough to properly negotiate a good contract for the people of Guyana. Now, you heard what Clement said, we're going to be decoding. Now, let's go to the provision as it relates to termination. For those of you who are familiar with the 2016 contract has entered into between the government of Guyana and ExxonMobile, we're going to take you to a provision, Article 29 of the contract. Article 29, and you can find this contract. It's available online. There was no way for me to put a copy of the contract up here so the public can see that contract, but it is public information. It's within the public domain, and you can go take a look at it. I know a lot of you out there are not familiar with the laws as it relates to contract, but that's why we're here this afternoon. We're going to try our best to decode portions of that contract for you. Now, we can't go through the whole thing. Obviously, we're only here for 30 minutes. So within that 30 minutes, we're going to try to decode as much of it as possible. Now, let's look at the termination and cancellation. Now, Clement, based on your reading and understanding of that contract, how can that contract be terminated?
The short answer is that it can't. Now, nothing is forever, so everything has to come to an end. But even before we go there, I wanted to preface my answer by saying, when you're appointed a steward of someone else's resources, and this is what the government is, the government has been appointed by the citizens of Guyana to act as a steward, as a fiduciary of the people of Guyana. That you have a legal responsibility to do the right thing in the name of the people who you're representing. It's almost like being an attorney, except you're hired to do a job, and the government is elected to do a job. And so when the government is either incapable of doing the job, then the right thing to do, the ethical thing to do, is to hire someone who is capable, or a group of people who demonstrate some capacity. And so to not do that is by itself a dereliction of the duty, a fiduciary duty that a government has to act as a steward to the resources of the country, which are the resources of the masses of the people who the government was elected to protect. So notwithstanding that, if you don't know, in the unconscionable argument that I was making, that they ought to have known better, but if you don't know, then you need to go get the people, and to not get the people is itself, the right people, is itself a breach of your agreement with the citizens of Guyana. Now, this is the termination clause. Hopefully in the future, maybe we can go back and start from the first article and work our way down. But the termination clause is an example of how unequal the agreement is. because it really cannot be terminated by Guyana. In fact, if any part of, they have several contracts with different parts of this oil block or oil blocks. So if any part of that operation, any section is operating legally or had not been stopped, then no, you can't stop any other part. You see, so just to be a little clear, if one part is ongoing, if you have a problem with another zone, you can't stop the zone you have a problem with. You have to stop the whole thing. And to do that is almost impossible, right? So I made some notes. I don't have my glasses, but I'll try and read it. But that is the general, to terminate any license, which each section has a license, terminate any license, you have to, and if there's another license existing, then you can't terminate the one that you have the problem with. So you have to endure. And then you are required to send a letter 30 days in advance if you want, in case you're moving to terminate, right? This is why it's interminable. You have to send a letter 30 days in advance to the minister. And in this case, at this time, the Minister of Natural Resources was, what's the young man's name again, Shellon? During the 2015 government, the new government.
I don't recall. I know that's a previous administration.
The minister at the time was Trotman, and you look at the contract. When you get to look at the contract, you'll see his signatures is.
Oh yes, that's true.
His initials are all on every page, and signature at the bottom. So he would have to send a letter to them, and this is a contract that he signed. So he would have to send a letter to him 30 days in advance as he wants them to stop or whatever is his issue with. And then he has to give them 60 days to cure the problem or to respond. So the or to respond is that they could cure if they want, or if they don't want to cure, they can write a letter explaining why they don't want to cure. Now, if there's anything that is not resolved in that exchange, then they're allowed to negotiate among themselves as professional people an agreement. And if that doesn't resolve the problem, then they go to arbitration. And arbitration is a stealing of rights, because the Constitution said certain things, the Guyana Constitution said certain things, and the U.S. Constitution, these are the two parties are operating in two different jurisdictions, really, even though they've come together in one jurisdiction, Guyana in this case. One is operating as an American transnational, and of course, the Guyana government. So when you give up your right to court and agree to arbitration, you're giving up your constitutional rights, because the arbitration doesn't have to follow, you would hope it would, but it doesn't have to follow. It's a separate law that applies, right? And I can go on, Shellon. I don't know if you wanted me to stop there and with some questions.
I mean, the thing is, what people need to understand, before you even get to the arbitration, you need to know that if there's a dispute in this contract, what law is applicable in that dispute. Because to get to the termination and to see how you're going to be able to terminate, you have to have laws, right? And what law is going to be applied if there's a dispute in terms of if the party chooses to terminate, or if there's an issue as this. In this case, we've seen several issues arise, but the government of Guyana just sat idly by and allow ExxonMobile to basically do whatever they want. As you know, ExxonMobile owes millions of dollars to the people of Guyana, but the government of Guyana has not been doing or engaging in sufficient oversight to ensure that that money is paid to the people of Guyana. So the issue here, Claremont, what laws is going to be applicable to any dispute, or if there's a potential termination or the parties want to terminate, one of the party want to terminate, most likely the government of Ghana. Which law, according to this agreement, should be applied?
Right. So that's an excellent question. Not because I know you, but it gets to the heart of what I'm trying to say is that the parties are so unequally matched that it would be unfair to pursue this contract. And one of the reasons it stems from the question you asked, which is which law applies. And the contract says clearly that in the case of you having to go to court, the laws that apply are the laws of Guyana. And this is not unusual. It might sound as some kind of concession, given the size of Exxon, to instead of dragging the Guyana government into the U.S. court, it is willing to submit its 300 billion budget to the courts of a 3.5 billion budget country. So okay, that might be a win, but it's not, because you don't ever get there. You can't get to court if you're the Guyana government, because of what I just said about the termination requirements. And then the applicable law is if you end up in court at some point. That is my reading of it. I could be wrong. My reading is the applicable law is what happens in the national law happens in the national courts, and the arbitration process is not guided by that law, and it does not specify, particularly in the arbitration process, what law applies. And the reason I raised that question is because it says that all the disputes, any dispute at all, goes first to the arbitration, right? It doesn't matter what your dispute is. Between the parties, it goes to arbitration. And that arbitration is conducted by a group called the ICSID, which is an international body that handles international arbitrations. That body has a lot of powers. They can consolidate all the arbitrations into one and be heard by three people, which you will choose. But if that body decides not to arbitrate for one reason or another, it then goes to the UN Commission on International Trade, and they're using those laws. Now, that means that the Guyana Constitution goes out, whatever protections, the EPA and all that is out the door. We're using now a UN body using laws that are outside of Guyana, not formed by the people.
Foreign to Guyana. Mm-hmm.
Right. And then the people who are conducting the arbitration it's an American arbitration company. They can move around. They could hold it any part of the world they want. They could go to Guyana. They could hold it but it's based in Washington, D.C. That's where the head office and head arbitration office is. So you see how power is wielded. In fact, your constitution has no application. Your local laws have no application, even though it's mentioned in the contract, in the actual day-to-day operations of the company as it relates to the other partner or other contract, the other party, in this case, the government of Guyana.
Exactly, and a lot of people don't understand when the government of Guyana put the Guyanese people in such an awkward position where we have no power, we have no control over resource that actually belongs to us. It's a situation where we cannot win. And the applicant, although Article 27 of the agreement has the applicable law. And this portion, people should pay attention. Article 27.1 is that the agreement shall be governed by and interpreted and construed in accordance with the laws of the Cooperative Republic of Guyana and consistent with such rule of international law as may be applicable or appropriate, including the generally accepted customs and usage of the international petroleum industry. That means Guyana doesn't really stand a chance in terms of its law having no effect here, because we don't have much customs or any laws or rules applicable in the international petroleum industry. This is new. This is something fairly new to Guyana. And if Guyana wanted to get involved in something that we were just entering into the arena of something which is fairly new to us, we should have gotten the right tools, hired the right professionals, and put ourselves in the correct position where this agreement would have been equally applicable across the board. But the agreement essentially, as you heard Clement said, is essentially one-sided. The applicable law provision doesn't have any effect as it relates to Guyana, because as you can see, I just read it, and you heard Clement said that really everything goes to arbitration. So even if you apply in the laws of Guyana, it's still subject to what? International customs, international rules, international regulations in the international petroleum industry. So really, what does that really say in terms of where it puts Guyana, Claremont? Where
they are in a bind. And nonetheless, in addition to everything that I've said, the arbitration, whatever agreement the arbitration comes to, whether it's an agreement or a finding, is binding, which means that's it. You can't go beyond that. It's binding. So the only thing you can argue after binding is that you weren't in your right mind the day you signed, some stuff, or what I'm saying, unconscionable. It's so egregious, so one-sided, that the person who was on the other side was probably asleep or not well, or just didn't have the capacity. That's the only thing you can argue, and therefore it's the contract should be voided on that account. Of course, there might be other arguments, but I'm just speaking about the inequities. All right. So your question was what? I think,
as it relates to the applicable law, or law really not having any position whatsoever, even though Article 27 says that. Like, what position does that really leave Guyana in?
Mm-hmm. Well, we have to separate Guyana from Guyanese, or people, citizens of Guyana. It's not the same thing. And so the citizens of Guyana elected someone to go do a job, and they did what they did with the contract. And so in many respects, they're operating on behalf, right? But that doesn't prevent individual citizens operating on their own to challenge Exxon on the very inequality and other things. And in fact, the local law does. There are local laws that govern these kinds of operations, and specifically, there's an EPA, a board, Environmental Protection Association, that's constitutionally constructed, that has oversight. And there are laws that every citizen of Guyana is entitled to, climate, a livable climate, and free from the kinds of threats that the forces that may be unleashed by the development of oil, namely environmental degradation and so on. So the Constitution says that the EPA is charged with overseeing these operations like this, like Exxon in Guyana, Esso in Guyana, right? And my one of our colleagues, Melinda Janke, one of the local attorneys in Guyana, had helped actually draft some of that in, and she has had some oil. She worked for BP and has some experience, and so was able to put in some of those things, and we should be thankful to her and read what she's saying on these issues as well. But so there is law, but Guyana, the government, is foreclosed from access. That does not preclude people,
The
citizens from acting. They have acted. In fact, Melinda Janke herself has sued. Both EPA and Exxon are actually co-defendants and defending each other against two individuals, two Guyanese citizens who sued them. And Justice Sandil Kissoon, wrote a 56-page opinion chastising Exxon. So there's been victories, and they're victories based on Guyana law.
Yes,
But
I remember that
right,
case.
right. But as far as the government of Guyana is concerned, they have locked themselves into a very strange document. And moreover, it's not just themselves. I think we're coming up to that time. Let me close by saying that one of the things about termination and resolving problems, no asset is exempt from Exxon coming after Guyana in the event, and this is clear in the contract. They can sue the government, they can sue any agency, they could no asset owned by the Guyana government, which is by extension an asset owned by the people of Guyana, is free from Exxon to come after. So anything you're making in gold industry, they can come after that. In sugar, sugar has been losing money, but you get the point. There's nothing that's owned, no resource in Guyana is free from suit if Exxon decides that they've been wronged and they need to be repaired. They can come after any other asset. So we probably need to have the contract reviewed on that basis alone, if not a sanction. Well, before you even get the sanction, a complete stoppage of exploration until we can get a better contract. My own feeling, I think oil is a dying industry. It's really dead. It's just like hanging on. And I share that view with many people who, study and work in this area. To pursue it and spend all that money and time and resources is going to be a losing cause in the end of it. And maybe we should think about that as well.
I absolutely agree, because as you can see, a lot of states, especially here in the United States, is switching over to electric cars, and they're relying less and less on gas. So the gas industry is eventually it's going to start declining. It's already started to decline, and it's going to even decline even further. But I think Guyana could still make some amount of money from the resources that it has if we had a proper agreement between the government of Guyana and ExxonMobil. And as you rightfully said, Claremont, in Article 29.4, if people read that particular article, it tells you that even if we terminate or cancel this contract, it shall not affect any right or action existing, or any existing liability that we incur under the agreement. So if we incur 2 million, 3 billion, whatever it is, the liability that the people of Guyana would have incurred to allow ExxonMobil to do exploration and everything else as it relates to this contract, the country remain bound and liable, even if you attempt termination. So it's ironclad. Really, Guyana has no way out. Like the movie No Way Out, really, that's what we're looking at from the perspective of the Guyanese people. But like you rightfully said, Claremont, the people of Guyana still do have a remedy against ExxonMobil. They can still sue if they're wrong. It's just like when we had Omai Gold Mine in Guyana, there was a lot of people suing Omai for the cyanide spill. Same thing here. If things happen, the people of Guyana will still have the right to go to the court and seek a remedy against those companies. But I think it's such a shame that the government of Guyana itself cannot seek any remedy really against ExxonMobil, because everything, they're tied up to the United States. Every other country, if you go to any other country to bargain with Claremont, you have to subject yourself to their laws. You are subject to their rules. Except Guyana, you're not bound to the rules of Guyana. You go to do business there, especially such an important contract. They're allowing somebody else to have the upper hand as it relates to making a decision of such vital and importance to the people of Guyana. All right. Any other closing remark before we go, Claremont?
No, just again, thank you for elevating me from guest to co-host, and thanks to all the listeners.
Okay, guys, I want to say thank you so much for being here this afternoon again with us right here live on 107.1 FM. I've been your host this afternoon. My name is Shellon Washington, and I've been Chong has been a really great co-host, even though he provided a lot of content to this old contract for you guys to understand. We come here, we break it down for you, and this is for educational purposes only. If you would like us to bring you more information on that contract, just send me an email. Send me a message on Messenger on Facebook, Shellon Washington, and we will bring you more content as it relates to decoding the contract between the government of Guyana and ExxonMobil. Again, thank you so much for being our guest this afternoon. Thank you guys so much for staying here and watching and sharing the link and clicking the like button. And I'm going to show you a commercial as we go. I do hope that you enjoy the rest of your weekend. It's been my pleasure. I will see you next Saturday again at 4 o'clock. Thank you so much, guys. So this is attorney Shellon Washington, owner and founder of the Washington Law Firm, located at 455 Utica Avenue in Brooklyn, New York. We're specialized in medical malpractice, personal injuries, matrimonial law, and landlord and tenant. If you're in need of legal representation, please give us a call today. The number to call is 718-877-3100. Consultation is free at no cost to you. So call us today to see if we can be of any assistance to your legal needs. Again, the phone number to call us is 718-877-3100.